Hello and welcome to the module on environment laws and the regulation of mining sector in India. Mines have been operational in India since the pre-independence period, especially in sectors like coal, iron ore and other minerals like bauxite. Many public sector undertakings post-independence have been involved in mining operations. In recent times, private sector has also invested in and is carrying out mining operations. Uh, in the mining sector, a major thrust area is towards servicing industrial expansion, economic growth, and energy security in the country. The National Mineral Policy of 2008 seeks to achieve goals related to large-scale prospecting of minerals and large investments, which according to the policy are required to be implemented through latest technologies. There are statistics available in the Indian Minerals Yearbook 2012, which are part of this module. However, this sector on mining, like many other sectors, is regulated by a range of laws which relate to allocation of mining areas and leases, ensuring the national use of mines, overseeing the land acquisition, as well as the rehabilitation proceedings. What is of interest to us in this module is also the environmental and social implications of mining and the laws that regulate the mining sector. This is because each time land is converted for mining, either for iron ore, bauxite or coal, or sand mining along rivers or beaches, there are social and ecological consequences. It's only bearing this in mind that several legislations over a period of time have emerged that regulate the mining sector. These are, especially those which are of environmental nature, they are under the jurisdiction of the Ministry of Environment, Forests and Climate Change. The next slide actually shows you glimpses of different kinds of mining operations: coal mines, iron ore mines, mining over dumps, what an entrance to an underground mine looks like. This is important to understand the ecological and social impacts that the mining sector can have, and that's why it needs to be regulated. The learning outcomes of this module actually include understanding three specific environmental regulations and laws. First, related to environmental approvals under the Environment Impact Assessment Notification, forest diversion approvals under the Forest Conservation Act, and approvals to use of protected areas for wildlife if they need to be opened up for mining under the Wildlife Protection Act. We move on to looking at environment and forest laws related to mining. The first, as mentioned earlier, is the Environment Impact Assessment Notification and approvals. The procedure under the EIA notification, which has been issued under the Environment Protection Act, basically categorizes mining into Category A and Category B projects. Category A projects require approval from the Ministry of Environment and Forests and Climate Change. These are mostly mines which are more than 50 hectares of mining lease area. Category B projects are basically those which require approval from the state environment impact assessment authorities. These are mining operations up to 50 hectares of mining lease area. So those which are above 50 hectares go to the Ministry of Environment and Forests. Those under 50 hectares go to the State Impact Assessment Authority, Environment Impact Assessment Authority. This is important to know that where do you actually locate mining operations and how do you track the approval in case you want to do so, even if it means whether you are applying for a mining approval or also want to check if a mine operation around you is operating with or without an approval. The EIA notification, as mentioned earlier, is issued under the Environment Protection Act and requires all mining operations to at least follow 4 stages. The first 2 stages relate to the preparation of the Environment Impact Assessment Report based on a terms of reference that has been granted to the mine, depending on whether it's Category A and Category B. It is either the Ministry of Environment and Forest and its expert committee or the State Impact Assessment Authority, which will grant the mining the terms of reference. Followed by the EIA, any mining project would need to go through a public consultation phase. A significant component of that is a public hearing. followed by the public hearing and the finalization of the Environment Impact Assessment report based on the feedback received at the time of the public hearing. An appraisal is carried out by the mining related expert committee. At the Ministry of Environment and Forests for Category A projects, there are separate approval agencies and appraisal agencies for both coal mining projects and as well as other mining projects. So if you're a coal mining project, you will be appraised by the coal mining expert committee. If you are uh, any other mining like bauxite or iron ore, it will go to the specific committee on mining. This slide here actually shows images of uh, public hearings and how they are conducted, an image of what an environment impact assessment report would look like with a table of contents for you to understand the kinds of issues that get covered in this document. However, in recent times, while this procedure is clearly laid out in the environment impact assessment notification, there are also recent exceptions and changes that have come about through circulars, office memorandums, or clarifications issued by the Ministry of Environment and Forests. Here we list 3 of these. For instance, on the 27th of February 2012, the Supreme Court actually ordered that all mining leases, even under 5 hectares, will also require environmental clearance. This is important because till this order was issued, all the Category B projects were actually uh, basically between 5 hectares and 50 hectares. As I mentioned earlier, now all mines under 50 hectares would require an environmental clearance as Category B project. Subsequent to this, the Ministry of Environment and Forest actually in May of 2012 issued a clarification related to this. The second exception and recent change refers to riverbed sand mining under 5 hectares. And it is very clearly, through an office memorandum mentioned that all leases between 5 and 50 hectares will be considered as Category B2 projects. This is important because all Category B projects which are approved and appraised at the state level can either be categorized as B1 or B2, depending on whether or not they require an environmental clearance, environment impact assessment, or and public hearing or not. All Category B1 projects would need to go through an EIA and public hearing. B2 are exempt. There are specific guidelines issued by the Ministry of Environment and Forests related to this, which also apply to mining projects. The third exception and recent change is important also because since 2012, several office memorandums have been issued for exempting one-time expansion of coal mines over 16 MTPA. Very recently, basically after the new government was formed, there is another office memorandum which has been issued that public hearing can be done away with. There's an exception for public hearing which has emerged and can be done away with for all coal mining operations, or if they are expanding above 16 MTPA capacity. This is, of course, if the expert appraisal committee they actually have to exercise due diligence while taking a decision and to see which mines should be exempted and which mines should not be, and they should be also satisfied that this mine has actually complied with all the clearance conditions that have been stipulated in prior to the expansion taking place. Importantly, to understand, the Environment Impact Assessment notification clearly lays down the validity of a mining approval, which is a maximum of 30 years to start the production operations in a mine. There is also very clearly stipulated clauses for post-clearance monitoring. All mining operations, like other projects, have to submit 6-monthly compliance reports with the Ministry of Environment Forest regional office closest to them, and these regional offices also carry out monitoring every 6 months. Recently, powers have also been given to state impact assessment authorities to monitor the compliance of conditions for even Category A mining. So this completes the section on environment impact assessments. We move on to looking at forest diversions. It's important to understand forest diversions in relation to the environment impact assessment notification because Often, mining operations, like any other industry, also would require it would probably require both forest and non-forest land. So, if it requires both forest and forest land, a separate approval for diversion of forest land for non-forest use is required under the Forest Conservation Act. And there are very clearly defined steps under the forest conservation rules, which were issued as part of the under the Forest Conservation Act of 1980, which are which have been modified also in 2014, and which very clearly lay out how what is the process to be followed when any user agency, public sector or private sector, requires the use of forest land for any mining operations. Some of the key steps are: a user agency, in the present case it would be a mining company or an individual, needs to submit an application seeking for diversion of forest land from the State Forest Department. And in particular, this would mean the Divisional Forest Officer, which is located closest to where the mine is going to be set up. The DFOs need to inspect the site, prepare a report based on series of criteria, and forward their recommendations on whether or not the forest should be given away for non-forest use. Based on the DFO's recommendations, the Principal Chief Conservator of Forests, in between there is also the Chief Conservator of Forests who will review the DFO's approval, and then finally goes to the Principal Chief Conservator of Forests, forwards the approval to the Ministry of Environment, Forests and Climate Change. This practice of the ministry giving prior approval for forest diversion was actually institutionalized through the Forest Conservation Act, which is in operation today. And this is when the central government had recognized that there is uncontrolled and unprecedented rates of deforestation in the country, and the state governments are not being able to manage it. So that is also the history of the Forest Conservation Act. At the Ministry of Environment Forest level, there is also a Forest Advisory Committee which reviews the proposal and gives its recommendations. In the process of this review, the Forest Advisory Committee can call upon experts, make additional site visits, and seek any amount of additional information that it acquires from the user agency. Based on the recommendations of the Forest Advisory Committee, the Ministry of Environment and Forest can either reject or approve forest diversion proposals. So the recommendations of the FAC actually are not binding. And there have been several instances where either the Ministry of Environment has agreed or disagreed. In this module, there are links to 2 or 3 such examples which you can study more closely to understand how this decision takes place. After the Ministry of Environment Forest decision, it is actually the state government which needs to issue an order invoking Section 2 of the Forest Conservation Act, and only then the forest land can be transferred to the user agency. So you cannot actually start operation on mining if you just received final approval from the Ministry of Environment Forest. It only gets invoked with an order issued by the state government, and the state government has complete right on whether or not it agrees to or disagrees with the Ministry of Environment Forest. There are also related procedures which are critical to the forest diversion procedure. And these basically relate to compensatory afforestation, payment for net present value for the use of the forest land, and the monitoring aspect. All proposals for forest diversion need to do specific compensatory afforestation. They need to also deposit a very clearly calculated net present value for the diversion of forest land for non-forest use. These are what get deposited in a centralized compensatory afforestation planning and management authority fund. The details of this are again in the text of this module. The third set of approvals which are critical before us are wildlife related approvals. Believe it or not, actually some mining operations also start impacting wildlife areas. So, and these are protected areas like national parks, sanctuaries, community reserve, conservation reserve, which have been explicitly declared with restriction on human use for protection of wildlife. However, the construction of mine may involve the use of areas designated as national parks, sanctuaries, etc. For this, then the clauses of the Wildlife Protection Act 1972, later amended to 2002, which need to get invoked. In such cases, the project is referred to the National Board of Wildlife and a standing committee for approval under the Section 29 of the Wildlife Protection Act. Section 29 of the Wildlife Protection Act basically restricts any person from destroying, damaging, exploiting, or removing anything from areas protected for wildlife under this Act. Permissions may, however, be granted by the Chief Wildlife Warden. The procedure very clearly laid out in the Wildlife Protection Act says that mining cannot be granted unless the state government is satisfied in quotes, such destruction, exploitation, or removal of wildlife from a sanctuary is necessary for the improvement and better management of wildlife. So a mining operation would need to be justified that it's not going to impact wildlife, if it's not going to, definitely not going to enhance wildlife, but it should not be destroying wildlife. In the case of wildlife sanctuaries, the procedure entails seeking the permission of the Chief Wildlife Warden of the protected area of a particular state where the sanctuary is located. However, the Chief Wildlife Warden has to consult the concerned State Board of Wildlife before the permission is granted. For national parks, the consultation needs to be with the National Board for Wildlife and a standing committee, which has been delegated several tasks under the law. In addition to the areas within the protected areas, if any project requiring environmental clearance is within 10 kilometers, and this actually has been recently amended to being 5 kilometers of a national park sanctuary or a community reserve or a conservation reserve, would need to get the permission of the National Board for Wildlife. So you might be outside a protected area, but within 5 kilometers of a protected area, and you would need that permission. Very clearly, the National Board for Wildlife and its standing committee has a very important role to play. Prior to 2002, the National Board for Wildlife was actually referred to the Indian Board for Wildlife. Its composition and powers underwent a change in 2002 when the Wildlife Protection Act was amended. However, the National Board for Wildlife was only notified first in 2003, and its first meeting was held in December 2003. Like the IBWL, that's the Indian Board for Wildlife, the Prime Minister of India also chairs the National Board for Wildlife. The Wildlife Protection Act's amendment also stated that the National Board for Wildlife will have the discretion to constitute a standing committee to which it can delegate specific tasks and duties. In most cases, the standing committee does do the operational part of this task. Other than these laws, the Supreme Court of India has actually had a significant role to play in determining the use of forest land for non-forest use and which has come and also looked at other aspects of the mining sector, where especially when forest lands are involved. For instance, if any mining project requires non-forest use of a protected area, it also attracts the provisions of 14/2000 order of the Supreme Court under the T.N. Godavarman case, which is Writ Petition 202 of 1995, an ongoing case in the Supreme Court of India, which has far-reaching consequences in determining the nature of forest management in the country. This order actually bans the removal of dead, diseased, or wind-fallen trees, driftwood, and grasses from any national park and sanctuary. So basically, if any mining operation does take place, it would require removal of these dead, diseased. It would have an impact on the protected area, and therefore, any activity in a PA that amounts to such removal entails to take the permission of the Supreme Court of India. So that actually Supreme Court, not just in the 14/2000 order, under the Godavarman case has had several implications for mining projects, including renewal of temporary working permits, and especially when mining leases are yet to be renewed and forest clearances are required, and so on. Now that we're talking about the Supreme Court and the courts, there are two cases related to mining and environmental law which will be critical to even examine all this, the legal framework that we've been discussing so far. And these two cases are of different nature. One where the court has taken action in a specific, came much later to take an action in a specific mining operation in Orissa. The other relates to, and the first one relates to only one particular project. The other relates to a far-reaching policy change when it comes to sand mining in this country. So let's look at the first case. the first case actually talks about bauxite. It's a very famous case related to bauxite mining in the Niyamgiri hills of Orissa, in the eastern state of Orissa. Till 2004, the Niyamgiri hills spreading across Rayagada and Kalahandi districts of Odisha were known to a few. This changed when Sterlite Industries, part of the international London Stock Exchange registered entity, Vedanta, and the Orissa Mining Corporation disclosed their plans to mine bauxite here. Subsequently, 3 sets of cases were filed before the Supreme Court Central Empowered Committee, which was set up as part of the ongoing Godavarman case, which we just discussed in the previous slides. These cases actually highlighted a range of impacts that included those on the lives of the Dongriya-Kon tribal communities, for whom the hills are sacred, on forest produce, wildlife, sources of water which are emanating from these hills. One of the key legal issues from the very beginning of this legal battle was that Sterlite had initiated construction of the refinery, which was linked to the mine, without approval for the mining component. So they basically decided, it was a single project, but decided to break up and start construction on one component of the project without taking the forest approval for the mining. And this was integral to the project's viability. And it was mentioned in the Environment Impact Assessment report. The total mining lease area of this project was 721 hectares, but out of this 660 hectares was forest land in the sacred Niyamgiri hills. And that's why it required approval of a forest diversion for non-forest use under the Forest Conservation Act. Sterlite and the Orissa Mining Corporations, over a period of time when this matter was being litigated, linked and delinked the mining component several times over, just to ensure that their refinery goes on functional. There are links to various additional reading and articles related to how this really transpired in the text of the module, which you will read. In November 2007, actually something interesting happened. 4 years after the case was filed, or the cases were filed, the Supreme Court suggested that the mining could take place provided there is a special purpose vehicle that was set up by Sterlite and Orissa Mining Corporation. So they actually said Vedanta cannot mine, but the Vedanta subsidiary Sterlite can mine as long as they enter into a special purpose vehicle with the Orissa Mining Corporation. The Ministry of Environment, Forest and Climate Change subsequently rejected the proposal for carrying out the mining on 24th August 2010, and in between there were committees that were set up, there were interim other orders of the Supreme Court, which are again detailed in the text of this module, and additional links that have been provided along with it. And they basically said there were several reasons why this mining should not take place, also because it also violates the recognition of forest rights under another law that had emerged from the Ministry of Tribal Affairs. Sterlite and its parent company was not happy. They challenged this in the Supreme Court, and on 18th April 2013, a landmark decision which vested the future of bauxite mining in the hands of all the village councils, which are the Gram Sabhas, not the village councils, but the village assemblies, which are the Gram Sabhas in Niyamgiri. Almost 12 such Gram Sabhas were held under the supervision of the Ministry of Tribal Affairs, and all of them unanimously rejected the proposal. Following this, the ministry also issued a particular order rejecting the forest diversion for mining in Niyamgiri hills. So this case, reading more details about in this case in many more details, you'll realize all the issues related to EIAs, forest diversions, as well as impacts on wildlife get juxtaposed in this particular and enthralling case, which you could read through the links provided in part of this module. The other case is relatively more straightforward, although it's had huge implications on riverbed sand mining taking place in the country. On 5th August 2013, the National Green Tribunal, based in Delhi, passed a strong interim order which restrained removal of sand from riverbeds across the country unless requisite approvals by the Ministry of Environment, Forest and concerned state impact assessment authorities had not been procured. Again, MOEF and SIA are required to give separately process approvals for Category A or Category B sand mines. This had been a mandatory requirement following actually what the NGT was doing was reiterating a Supreme Court's judgment of February 2012, which amongst other things had really clearly said that environmental approvals under the EIA notification are needed for all sand mining projects and all activities, even under 5 hectares, which we had clearly referred to when we were discussing the EIA notification and its procedures. This judgment in Deepak Kumar versus State of Haryana and others had also made critical observations related to environmental impacts of sand mining before issuing these directions. Again, there are links provided in the text of this module which will give you additional information and reading on this particular case and the judgment. The NGT's follow-up order of 14th August 2013 reinstated this fact and took forward the non-compliance of the February 2012 order and judgment of the Supreme Court. The NGT order first acknowledges that there is rampant illegal sand mining that has continued despite the directions of the higher judiciary, and directs all state governments in India to respond to the 7 issues that they raised as part of this order. Since the time of the directions were first issued, the state governments have been submitting information to the NGT and what steps should be taken to implement the order. And this case is currently ongoing and is awaiting the final conclusion and judgment from the Green Tribunal. This module also leads you. This basically we are almost at the fag end of the module. But this module also gives you insights into and leads into 2 very, very critical and interesting processes which have shaped the mining sector in India to a large extent over the last 3 or 4 years. The first is the M-15 Commission and Inquiry into iron ore mining in India, and they have given state-specific as well as national overarching reports on iron ore mining. Based on this report, additional inquiry commissions, including the Central Empowered Committee, has been looking at iron ore mining and all the illegalities related to allocation, as well as environmental and forest clearance issues under which their non-compliance has been high. In fact, based on this M-15 Commission report, iron ore mining in Goa, in the state of Goa, had actually been banned for a very long time. So, actually, delving deeper into this, the M-15 Commission and how it was used in the Supreme Court and what implications it had, would be very important additional reading to locate environmental law in the socio-political context in the country. The other case, which is again very, very significant and is reshaping the coal sector and the coal block allocations in the country, is the Supreme Court case on coal mining allocations. August and September of 2014, there were clear directions and judgments issued by the Supreme Court, which actually cancelled the allocation of 218 coal blocks, which had been allocated since 1993. So, as part of this module, what have we really looked at? If you need to summarize the whole module, what have we really tried to address in this module? And I would request you to read the module in detail and understand it 2 or 3 times before, because the legal overlaps can be a little confusing. So what have we looked at? The mining sector in India is regulated by a range of laws, and we are only dealing with the environmental laws here. I'm not even dealing with the pollution related laws, environment impact assessment, forest diversion approvals, and wildlife related approvals. So each time, and this is important because each time land is to be converted for mining, there are a wide range of ecological and social implications of such land use change. What this module has dealt with are 3 regulatory frameworks which lay out procedures and safeguards that mining agencies would need to follow prior to initiating operations. These are quote-unquote environmental clearance under the Environment Impact Assessment Notification 2006, forest diversion related approvals under the Forest Conservation Act 1980, and approval for the use of protected areas for wildlife under the Wildlife Protection Act of 1972, amended in 2002. Following a description of procedures and recent changes and implications of these laws, what this module also tries to do is it locates the application of these laws in 2 landmark cases related to bauxite mining in Niyamgiri Hills and the restriction of sand mining, especially the riverbed sand mining, across the country. It finally gives a glimpse into 2 significant legal and policy processes that have had a significant bearing on regulating iron ore and coal mining sectors in India. I wish you all the best and with the assessment and the learnings of this module. Thank you.